I want my mother's 50%. I am entitled to it. My mother was married to this man who I call my father. But now, as her child, I am entitled to get her 50% and I want it. And therefore, everything must be shared in this manner. How many times have you heard that? Well, that's a regular statement a lot of people make when they have lost either one of their parents who were married in community of property. I want my mother's 50%. I am entitled to it. Does the law support this stance? Does the law support this particular statement and this demand? Well, it's interesting. Let's talk about it, right? Because again, we agree the mother or the parent that passed away was entitled to 50% by virtue of the marriage. But one thing you should keep in mind as we have this discussion, this particular parent we're talking about did not have a will. And so this is then where the demand comes from. Is it justified in terms of the law? We've got to talk about it. Listen, if you're new here, welcome. My name is Yolanda Mnyengeza. I'm an attorney and a director at a law firm here in Johannesburg, South Africa. And to all the folks that are returning here, thank you for coming back. Well, let's talk about this particular issue today. Let's go. Now, am I entitled to 50% that my mother was entitled to in terms of her marriage? Now that she has passed away, now that she has not left a will and I am her only child, am I entitled to that 50%? Well, let's start at the beginning here. Remember, when a person gets married in community of property, in terms of South African law, they share everything jointly, meaning all of their assets, they own them equally, 50-50. With regards to their debts as well, they are responsible for those 50-50 by virtue of what? Of the type of marriage they're in. So when the mother does pass away without will, obviously they did have an entitlement in terms of the law. But then what is meant to happen in this situation? Because they never wrote anything down. What does the law say about this situation? Well, let's start it from the right of each person to draft his or her own will. In South Africa, we've got what we call freedom of testation, which means that everybody in South Africa has a right to dictate what should happen to his or her own assets when they pass away. And this includes people married in community of property. Often people have the understanding that because they're married in community of property, maybe they can't draft a will because they own everything jointly with the other spouse. Well, you can draft a will because you'll be speaking to your own 50%, which is your share, right? So you'll be dictating what should happen to that entitlement of yours, to those assets of yours, right? So this is a right given to everybody. Now, when you do take this particular step as someone who's married in community of property, what happens? So what happens is that we distribute things according to what you had said in your will. So which means everything has to be split in the middle and your 50% has to go to the people that you've listed as your beneficiaries, as your heirs, right? So then everything gets split in accordance. No question, no issues, because you have what? You've got freedom of testation that allows you to do this, that allows you to dictate what must happen to your assets. And again, just to add, because some people tend to think they need the consent or a spouse to accompany them. Is that the case? Well, no, you don't need anyone to accompany you. Just because you're married in community of property doesn't mean that your freedom is limited. Freedom of testation means that you've got the right to dictate how the things will be inherited, and you don't need anybody to give you any consent about the things that you have, right? So you've got every right to go draft your will on your own. And like I said, Everything will happen according to your instructions pertaining to your own part of the properties. Now, what happens in this instance? You are married in community of property, right? And you've got a child or you've got children, and you don't draft the will. In most instances, what is expected by both the party that passes away often and those that are surviving is that automatically what's going to happen is that the 50% that this person was entitled to is just going to go to the kids, because obviously that's what they were entitled to. That's what a lot of people expect. But what does the law say? Does it agree with this particular stance? Well, newsflash, it does not. Because in South Africa, when you die without a will, in order for us to determine what and who's going to get what in terms of your estate, we're going to look at a legislation which we call the Intestate Succession Act. And according to the Intestate Succession Act, if you did not draft the will, there's a lot of things that we need to look into. And so it's not going to be automatic that your 50% goes to your kids. If you did not stipulate this, the law is going to dictate for you. And it doesn't say that 50% of yours moves from your estate to your kids and your husband or your spouse doesn't get anything. In actual fact, this is how it works in most instances. First things first, if you die, you don't have a will, you were entitled to 50%, and you've got a spouse and you've got children. In terms of South African law, the first thing the first person who's going to inherit from you is your spouse. What does your spouse inherit? Well, it's going to depend on the value of the things that you were entitled to, your 50%. How much is it? Right? So first things first, it's either the spouse is going to get 250,000 Rand. Alternatively, they're going to get what we call a child's share, right? What is a child's share? So a child's share is when we take the value of your estate and divide it by the number of children as well as your spouse, and then we see how much that is going to be. If the child's share is lower than 250,000 Rand, well, the spouse is going to get 250,000 Rand because the child's share should be above if the spouse should get that, right? So when the spouse takes away his or her 250,000 Rand, whatever's left is going to be split amongst the kids, right? And this is after everything has been split in the middle and the surviving spouse has gotten what they were entitled to. So in addition, in your 50%, they're also going to be entitled to 250,000 Rand, or alternatively, if there's much more, they're going to get a child's share. So in essence, the kids that are there may inherit, may not inherit, depending on the value of the things you've left behind. And they're not necessarily going to get the 50% that you were entitled to. So do you see the danger of you not drafting a will? So always understand these things. Never make assumptions about how things are going to work, right? Meet your legal practitioner, understand where you stand, and then make preparations. If you have the desire for your kids to get your full 50%, don't assume that's what the law is going to do for you. The law decides where you don't want to make a decision, where you don't take the initiative of drafting something. Then it says, okay, we'll do it our way. And our way, or the law's way, may just not be what you want. So that brings us to the end of our discussion today. And I'm hoping that that actually answered your question, that actually put you somewhere about that particular issue. So the next time you hear someone say, I want my mother's 50%, I want my father's 50%, I was entitled to it because my mother or my father left it behind. Now you know what you can tell those people. You might not be giving them advice, but you'll be giving them a heads up to say, I heard from someone, right? Because we are also sharing information with the hope that it's going to help people, especially shift away from the belief of certain misconceptions that often lead people to make decisions that are not necessarily going to be helpful to their families. So, like I always say, if you found this useful, you better come back, share it to others so that they can also see it. Why not get educated in the masses, right? So we'll see you next time. Again, my name is Yolanda Mnyangeza. I'm an attorney and a director at a law firm here in Johannesburg, South Africa. Let's talk next time.